Well, thank you very much, Jose Antonio. That was a very generous introduction, and it's great to be back in The Hague with so many friends and colleagues. And as Jose Antonio mentioned earlier, this conference has been in the works for a couple of years and is a bit of a labor of love, particularly for Jose Antonio. He was very dedicated to making this work, and the organizers here were equally enthusiastic participants in making this happen. So thank you to the law school, Eric and Yannick and Reza. It's great to be here. We had a really good start this morning for those of you online who weren't able to see our excellent keynote speaker and our conversation. We've already dug right into some of the key issues. The latter part of today, the panels 1, 2, and 3, which will follow, deal with first, and this panel dealing with jurisdiction and admissibility and that intersection of those ICJ and PCIJ cases with ISDS. And will be followed after this session with a further session dealing with merits and substantive issues, and then followed by that with a session on compensation and damages. So we're really trying to give a bit of an introductory course in some ways into that intersection between these two areas of practice. And to follow up a little bit on my background from Jose Antonio's introduction, when I started working in international arbitration, and I did have the privilege of diving right in as a young lawyer into some of the first investor state arbitration cases in the NAFTA, and we brought cases against Canada and the United States. And it really was a time when there wasn't precedence, there wasn't jurisprudence that we could look to in the sense of other ISDS cases. There were very few. There was, of course, cases like ELSI and Asian agricultural products. So, we knew all about shrimp farms and Italian expropriations, but there really wasn't much else, unlike the 1,000 some odd cases which current practitioners can now delve into and look for some guidance and persuasiveness. But one of the things we did, and this was a great privilege as a young lawyer, was to look at some of the ICJ case law that had been developing over the previous 50, 60 years. And in particular, and we're not touching upon it today, there is actually a wealth of claims tribunal cases out there from the late 19th century and early 20th century, the Mexican and Venezuelan claims tribunals and so forth. And that's an area that actually we're not discussing today, but one which I think deserves much more study. There's a wealth of interesting thoughts and treatment in those cases on public international law. And of course, one of the most famous cases is the NAFTA case, which became a bit of a bête noire, was the NEAR case, famous NEAR case, about which was used to help interpret fair and equitable treatment standard, but in reality was more of a full protection of the security case. But that's perhaps for the next panel. We want to address jurisdictional and admissibility issues. So why don't we get right into that? We have a great group in front of us, and we are going to divide up our task in the roughly hour and a half that we have assigned to us. Our first part of the session will be given by our presenter, Professor Anastasios Gourgourinis, who is an assistant professor of public international law at the Faculty of Law of the National and Kapodistrian University of Athens. I hope I got that right. And he specializes in international economic law, and as a research fellow at the Academy of Athens and an associate member at the Centre de Recherche sur le droit des marchés et des investissements internationaux de Dijon. So not too far away, and at the Université de Bourgogne. He also holds an LLB and an LLM from the Faculty of Law of the University at Athens. And of course, PhD from University College London. So Anastasios is going to start off with a presentation, kind of introduce us to the cases that we are planning on discussing. And I'll briefly outline which of those cases are, and then he'll get into it. But before that, I just wanted to introduce our commentators as well. We have three excellent and experienced individuals who will provide a little bit more context around the question today about that intersection between ISDS and public international law and ICJ and PCIJ cases. And sitting directly to my right is Professor Filippo Fontanelli. Filippo read law at the University of Pisa, where he has a degree and master's, and the Santa Ana School, where he has a diploma de licenza and a PhD. He's worked in private law, but as well, he, of course, is a professor at the University of Edinburg. And he has many credentials and is very experienced, and looking forward to hearing more from him on one of the key issues, which I'll introduce in a second. Next to Filippo is Ms. Diem Huong, who is an attorney at Foley Hoag. Diem works in Foley Hoag's International Litigation and Arbitration Department. Her practice is focused on sovereign state matters, public international law, and international investment law. So very appropriate for today. Prior to joining the firm, Diem had worked for a number of years at the Permanent Court of Arbitration, focusing on the theoretical aspects of more than 17 cases administered by the PCA, including interstate and investment disputes relating to land and maritime boundaries, law of the sea, natural resources, infrastructure, construction, and confiscation of real estate and assets. It's great having you here at Diem. And next to Diem, and last but not least, is Professor Kiran Gore. Kiran is an arbitrator and a practitioner, dispute resolution consultant for over 15 years. She advises governments, corporation institutions, individuals, and public and private public and private international law. As well, she is a professor at the University of George Washington in Washington, D.C., at the law school there. So thank you very much, Kiran. It's great to see you and have you today. So in terms of our schedule, I will ask Anastasios to kick us off. He's going to discuss a number of cases, some cases that are well known to most of us, perhaps a few new cases. Very specifically, we're going to look at the Georgia and Russian Federation case on the application of the International Convention on the Elimination of All Forms of Racial Discrimination. The fisheries jurisdiction case between Spain and Canada. Oil platforms, of course, is an important discussion. The armed activities case between the DRC and Rwanda. Mavromatis, of course, is always a good topic in this area. And then finally, we're going to, if we have time, look at the Azerbaijan-Armenia case because it has some interesting new issues concerning ratione temporis. So a mouthful, ambitious schedule, but I think we're up to it and looking forward to hearing from our great panel and presenter. So let me hand it over to Anastasios and away you go.
Thank you very much, Ian. So, first of all, I would like to thank the organizer. I would like to thank Yanni. I would like to thank everyone for being here today. Now, I will start with a disclaimer. The selection of cases was made. It is actually the result of exchange of opinions between the members of this panel. So, it does not serve as an indication of all the cases we feel that should be prioritized when discussing the influence of ICJ, PCIJ case law in investment arbitration. So in a sense, there is some arbitrariness involved, but please bear with us and hopefully we will be able somehow to justify this election. Now, the second disclaimer has to do with my role. Now, obviously here, I will speak for 30 minutes, which is a good thing and a bad thing. But my role is essentially to pave the way for the analysis by my prominent colleagues. We're going to be discussing issues pertaining to consent, jurisdiction, and issues regarding admissibility. Now, in this respect, I will be presenting 6 cases, so I plan on spending like 5 minutes per case. I will be giving a brief overview of the facts of the case and the position of the parties, as with an emphasis on jurisdiction and admissibility. And then I will also be briefly flagging, not really commenting on the findings of the court in each of these cases. And whenever the situation, whenever there is such an opportunity exists, I will also be making a small link with potential references of these particular cases made already in known investment arbitral case law. So, if I may, as I'll start from the fisheries jurisdiction case, I'm actually referring to the Spain Canada one because there's also a couple of other cases out there with other parties. Now, this is a case filed in 1995, and it was filed by Spain against Canada. And the crux of the matter was measures taken by the government of Canada with respect to measures for conservation and management with regard to vessels fishing in the Northwest Atlantic Fisheries Organization regulatory area. I will be referring to it as NAFO. Now, what is of interest for the purpose of this panel is the fact that there was the main jurisdictional disagreement between the parties had to do with the definition of the dispute. Now, on the one hand, Spain took a broader view. The idea was that this dispute pertained to a number of alleged violations by Canada regarding its obligations under the law of the seas, the freedom of the high seas, and not just to conservation and management measures, as was the position of Canada. Now, obviously, Canada argued for such a more was Article 36, paragraph 2 reservation that it had already made. And that reservation, and if I may quote, excluded disputes arising out of or concerning conservation and management measures taken by Canada in the said area. So it was a paramount importance for the court to be able to see whether the dispute as presented by Canada, but not just as presented, but in essence, whether the dispute brought before it fell within the scope of its jurisdiction. Now, among other things that we'll be discussing, I think this case is very interesting because it's one of the few international cases which discuss the contra proferentem rule. It was one of the few instances where the contra proferentem rule, which many of you may already be familiar with in the context of contractual statutory interpretation, whether this rule could also find its interpretative maxim, could also somehow find its way in the interpretation of treaties, or at least the reservations to declarations under Article 36, paragraph 2 of the statute. Now, eventually, the court sided with Canada. It found that the dispute as presented by Spain, but also in essence, fell outside the scope of the consent provided by Canada, where extended the compulsory jurisdiction of the court under Article 36, paragraph 2. And in this respect, the court made a number of very interesting remarks. The first remark had to do with the fact that jurisdiction has nothing to do with party autonomy. It is not an issue which pertains to the parties. It is an issue which pertains to the court. So it is for the court to decide. Now, an asterisk here, and I'm certain that my colleagues will discuss it later on, is this actually transplantable in investment arbitration? Because in interstate cases, one would see the merit of this proposition. In investment arbitration, I would not be so sure unless one speaks of derivative rights instead of direct rights to foreign investors, but we'll discuss that later on. The other interesting point has to do with the fact that whether there should be a restrictive interpretation of reservations according to declarations under Article 36, paragraph 2. The court then said no, there is no need to go for a restrictive approach to interpreting the unilateral declaration, but what it did say, and this is quite interesting, it's actually one of the few cases that we have, this is said that nevertheless we should not apply per se the Vienna Convention when interpreting these reservations. We should apply by analogy, perhaps, the interpretive maxims, and actually this is what the court did. But it is not directly, the Vienna Convention rules of interpretation, Articles 31 and 33, are not directly applicable. And the last point had to do with contra proferendum. Contra proferendum was actually a very good point. Why? Because it provides a very easy solution. In case of doubt, the party that actually drafted an instrument takes all the blame and suffers the consequences of the vagueness of its relation. So obviously that was a key assertion on behalf of Spain, because the idea was that if the court would accept the contra proferendum application in interpreting the reservation by Canada, and if the court would accept that it was vague enough so that the contra proferendum would apply, that would be an easy win for the Spanish side. Nevertheless, that did not really materialize. The court was not persuaded. And the last point in this case, to my knowledge, it has not been referred to in non-investment arbitral case law, but I can only say that the contra proferendum rule has been referred to once, if I'm not mistaken, in passive, in a NAFTA case. Perhaps some of the audience or Ian, who's an expert, may refer to that case. So there is an indirect link. Now, let me proceed with the second case, which is the Georgia Russian Federation case. That was a case on the basis of the infamous banal Article 22 of the Convention for the Elimination of All Forms of Racial Discrimination. Okay, we have heard a lot. We'll be hearing a lot about Article 22 and similar compulsory clauses in the future. May I say here that this is a case where initially the court granted provisional measures finding that the prima facie had jurisdiction, but when the case, when the jurisdiction was actually examined at the procedural objections stage, said that I do not. Now, the interesting point here that one may keep when it comes to potential relevance for investment arbitral case law have to do first of all with the concept and the characteristics of negotiations proper. So what are negotiations? The court, I think, made it very clear and very clear and in so many words that negotiations are not mere protest. So by merely protesting, you may be indicating that the fact that there is a dispute, but it's not enough. You need some positive action, at least a positive or a genuine attempt to settle the dispute, and this is only possible if such an attempt has actually been made. Served here is of course it is a strange animal in the sense that does not only refer to negotiations, it also refers to the procedures that are underserved in a disjunctive way. So you must either go to negotiations or exhaust the procedures underserved before you can seize the court. Now, this was reiterated by the court. It said that yes, obviously these are legal requirements going to my jurisdiction, so it's an issue of consent. It makes that clear. Without the fulfillment of these requirements, the court cannot be seized. And again, I repeat, this is an issue of consent. It is not an admissibility issue. It also clarified that the obligation to negotiate is not an obligation just to enter into negotiation, but actually an obligation to pursue them as far as possible. Now, this is perfect for lawyers because you can construe to as far as possible as being a hard gun according to your client's interests, which is always a great thing. Now, there was a passage, nevertheless, which is not really popular. The passage saying also providing for another futility exception. Now we know the futility exception for the law diplomatic protection and exhaustion of local remedies analysis, but the court also hinted that obviously if negotiations are futile, you do not have to pursue them as far. So this futility exception was again quite interesting because I think that it also comes in other cases, but we'll be discussing that later on. Now, from the non-investment arbitral case law, the Georgia-Russia case has been referred to, for example, once in a 2012 case, the PCA case actually, but those here before, ICS versus Argentina. And the arbitral tribunal there was very quick to find that it is a matter that the ICJ in the Georgia-Russia case actually exemplified that the requirements of negotiation or exhaustion of or available procedure is not just semantic, that it is a legal prerequisite, and did that actually, and the Universal Arbitral Tribunal did that exactly in order to construe the ISDS clause in that very BIT. So I think that here the influence of this particular case, investment arbitral case law, is not up. Now, oil platforms. So obviously, it's not the Iranian assets case, which has captured the attention of everyone, but still, oil platforms is a joy to read. It's a joy to read not only because of the very text of the judgment of the court, but also because of the very famous, I would say, dissenting opinion of Judge Higgins. Now, Judge Higgins actually established the prima facie test. I think that this prima facie test, which perhaps purportedly comes and also distinguishes clearly between what jurisdiction and what admissibility is, how you separate the merits. And I will actually even call it like a guideline or a guide for arbitrators in order to avoid doing terrible mistakes when resolving cases. It's my personal opinion that if you follow this, I think you would be safe enough. And this is actually why you have arbitral case or investment arbitration referring to the prima facie test as part of the jurisprudence constant in investment arbitration. Now, this is very, very important. Jurisprudence constant is not always used. It's not something casual. Arbitral tribunals would say that if they feel very much convinced that something has become part and parcel of the body of investment arbitral jurisprudence. Now, what is great about the prima facie test, and this is great for the respondent side in an investment issue, you can bring on facts from the merits, and even if you lose, you can actually discredit the case of the claimant. Now, from strategic purposes, the prima facie test is always very good. It's a very good alternative. Now, I will briefly refer to the famous passage in Professor Higgins' opinion, which I essentially said the prima facie test is simply accepting pro tem the facts as have been alleged by the claimant, and assuming that the facts are as alleged, whether that could in principle constitute a violation of the obligations suggested by the claimant. Now, this does not mean that you enter the discussion about the merits. This is not a definitive finding. This is only an incident. This is not even an incidental finding regarding the merits. It's simply an exercise in order to do what? In order to somehow give some leeway of judicial economy, so as to avoid going into the merits in a case where you would actually end up with a finding that's totally improper. By the way, this is what happened in the oil platforms case. So if Judge Higgins if her opinion was actually shared by the majority of the court, would not have the 2003 judgment. So now I refer to the Strabag versus Poland case, which refers to the prima facie case as constant. Now, again, a less known case, at least in investment arbitration, Congo versus Rwanda, one of the myriad of cases pertaining to the African continent and the things and the very bad things happening there in the year 2000. But that was a very interesting case. Why? Because in that case, Congo used multiple compromissory clauses. So if you want to read a unique case about having one application using multiple compromissory clauses, or even the attempt to use cogents as a legal basis for finding jurisdiction, go read that case. It is very interesting. Now, I will focus here on one of those compromissory clauses, which the court, the court did not find that it had jurisdiction, so it dismissed the case. But I will focus on one of those grounds, which is Article 29 of the Convention on Discrimination Against Women. Now, that was a convention where both DRC and Rwanda were parties to. That convention had a particular twist. It referred to the exhaustion of both negotiations as well as arbitration. So you could not go to the ICJ directly. You would first have to negotiate. Then you have to go to arbitration, and only if the outcome of the arbitration was not satisfactory, you need to go to the ICJ. As there is here, it is something similar like an appeal court, or which not give ideas to the multilateral investment court aficionados. Okay, we'll pass that for, we can discuss it in the during the discussion. Now again, the court was very careful in saying that that DRC fulfill neither of those two requirements. It did not enter into negotiation. So the fact that it protested does not mean that it negotiated. The fact that it protested was pertinent to establish that the defect existed, but said nothing about whether there was a positive attempt to negotiate. But it also placed emphasis and said that yes, but in any event, you did not go to arbitration, as was also required by Article 29 of the said compromissory clause. And in response to the assertion by Bagieta, if negotiations were impossible, how would I be able to go to arbitration? I said, now this is totally irrelevant. Now these are two distinct steps, and I think this speaks for how the court addressed this matter. Now here again is one of the cases where we don't really find any references to, or at least interesting references in non-investment arbitral case law, as far as I'm aware. Now, the usual suspect, Mavromatis Palestine concessions case. Now we could actually dedicate the entire panel only to discuss the Mavromatis case. I think that public international law 1.0 would start from what is the definition of a dispute. We all cite Mavromatis. Sometimes I feel that we should reread Mavromatis because the court said much more about, first of all, it did not refer to the legal dispute, but simply referred to the concept of a dispute, and that may matter. But now, what I will say about the Mavromatis case is that obviously, apart from the fact that you had the definition of a dispute as being any disagreement over a point of fact or law or a conflict of legal views or interest between two persons. And that is also what is revolutionary is referring to two persons, where in the PCIJ era, it did not refer to courts, it did not refer to states, it referred to persons. So it left somehow open how international justice would be in the 1920s open to other actors of international dispute settlement, but let us discuss it perhaps later on. Now, I have been given. I was very happy and fortunate to receive some points from Filippo, and he brought to my attention the fact that in the Mavromatis case, there was another instance where the PCIJ actually alluded to the possibility of invoking a futility exception when it comes to negotiations. Now, this is something again that not many know, not many was there. So I'm fortunate having Filippo being the commentator here. You get all the tips, but also this has also been seen in references in investment arbitration. But there you see, while you are able perhaps to trace a trend of siding with the possibility of invoking the futility exception when it comes to negotiations requirement, there are some arbitral tribunals who are not ready to do so. This is where the demarcation between interpretation and modification comes into play. Perhaps it is something for the discussion to follow. Now, another very important point is that jurisdiction is that jurisdictional flaws can be cured. Again, this is something that Filippo brought to my attention, and I think that I personally am very eager to hear how he further elaborates on that. And there is also the ratione temporis scope when it comes to assessing the jurisdiction of the PCIJ. So here we have arbitral tribunals have taken this position by the PCIJ in Marmada's case with a pinch of salt. Some of them actually apply the findings of the PCIJ in Marmada's case when it comes to ratione temporis jurisdiction. Some arbitral tribunals have said that no, this is not transferable to the investment arbitration sphere. Whether this is a systemic issue or whether it is, or there are systemic reasons for this, or whether it has to do with the particularities of the given case, perhaps it's something will be returning to during the discussion. Now, closer to not closer to our hearts, but closer to dates is Azerbaijan versus Armenia, one of the cases between the two states. So here again, it has to do with CERD. Article 22 of CERD is also at issue. Diem is going to be discussing it in detail. 3 jurisdictional objections. The second jurisdictional objection without an object, because it was actually not there was actually no. Anyway, we will be discussing that perhaps later on. I'm running out of time, but a number of points which Diem will further elaborate on. The definition of an act of continuing or composite character, extremely important, especially for jurisdictional purposes. And it leaves open the possibility that even for acts that occurred before the critical date, to the extent that they are part of an act of a continual or composite character, if the violation took place after the critical date, you will be able to take into account the facts before the critical date. Now, for evidentiary purposes, in order to win a case, is extremely important. So I'm very interested to hear Diem's analysis in this respect. And so I will. I'm very happy to say that I have more or less covered all my points in less than 30 minutes. But so I can make a
donation.
Yes,
Can you
exactly.
donate a few minutes?
Thank you very much. Apologies if I was going too fast, and I'm really looking forward to hear what my colleagues have to say.
Well, thank you very much, Anastasios. That was great. And I wanted to move on from that excellent summary to take us up a little bit to a higher oversight. As all of us here knows, we hear the expression jurisdiction and admissibility. To the extent that, at least in the ISD context, we see decisions on jurisdiction and admissibility. And of course, when many of us teach the subject, and we are covering the classes on jurisdiction, and we have to describe to our students, oh, what's the distinction between those concepts? Most of us kind of skate over that. And for good reason. Tribunals skate over it. And I had the pleasure of talking with our next commentator, Filippo Fontanelli. I don't know, it must have been almost 10 years ago, maybe 8 years ago. And he was very much interested in this topic as to how we can look at these two concepts together, whether we can distinguish them. And I think where he came to, and I really do recommend a paper he wrote for the Brill Perspective series on international investment law and arbitration, which actually I co-edit for Brill with my colleague here, Dr. Sabahi, incidentally, so give Brill a plug. But Filippo was very generous in doing actually a very detailed 2-part article on this very issue. And when the topic of this conference came up, he was at the top of my list. So I'm going to ask Filippo to take us through some of his thinking. And I know in a very short time, you can't get into all of it, but it really helps introduce some of the cases to follow as well.
Thank you very much, Ian. And can you hear me in the back? I think so. So yeah, yes, that's a wonderful topic. Thanks, Ian. Thanks, Jose Antonio, the Leiden team, everybody. So Anastasios, thanks for the introduction, and a couple of minutes I will expropriate from you. So these are ICJ cases that have some relevance, I believe, to the topic of jurisdiction and admissibility. And I will deal in particular with one perhaps preliminary topic, which is how do we distinguish jurisdiction from admissibility? And if you allow me, I will only talk about inadmissibility. There's no such thing as admissibility requirements, and therefore there's only the possibility of inadmissibility as a remedy. And that, I think, puts some order in our ideas. I also want to make a caveat that I presume extends to the entire day, but I have to make it, I only talk about treaty-based ISDS. The several forms, I only talk about treaty, because treaty-based ISDS is the one where jurisdiction is based on the consent, which is based in the treaty, okay? So that's that doesn't narrow very much, but I think it's important to say. Now, we've heard talks of reverence of tribunals to the ICJ, and in this specific angle of the discipline, we have a serious case of irreverence. There is insufficient deference. Sorry, that's what you get when you invite me on my pet peeve. Then I get animated. That's insufficient deference to the ICJ fairly clear approach to distinguishing jurisdiction and admissibility in investment arbitration. And we can take, for instance, the armed activities, DRC Congo, but also Georgia, Russia, Djibouti on mutual assistance, the recent case on award of 3 October 1899 between Guyana and Venezuela. All these cases say very clearly the jurisdiction is based on the consent is based on the treaty might contain limitations on the consent. Those conditions limit the jurisdiction. It's very clear, it's very linear, and I know we will talk about consent, so I will stop it there, but obviously that raises the question, well then what is admissibility, or rather, what objections can refer to the inadmissibility of the application or the claim? If everything consent is jurisdictional, well, everything that is not about consent. And I know it's obvious, but for some reason it's overlooked because it sounds like several truisms. And so I believe that bit is so crucial and so misunderstood. Everything that is not about consent, but for some reason, usually that has to do with substantial or procedural justice, can prevent the continuation of proceedings to prevent injustice, well, can be raised as a possible grounds for inadmissibility. Now, so the oil platforms case, and the famous part is the Higgins test, which I believe goes to the distinction between jurisdiction and merits, so I'm happy to leave it aside. But it also says, with regard to some of the US claim that Iran could not defend itself after having breached the treaty, so some sort of clean hands. And the court quickly said, by the way, this objection of the US is not about jurisdiction and is not about admissibility because, and it's interesting, because it doesn't go to the alleged conduct of the claimant. This is interesting because, again, it draws a distinction between objections that are based on consent and lack of consent, and other things that have to do with the conduct of the claimant, and that raises questions of justice and fairness. Now, what about the heritage, the legacy in investment treaty arbitration? The situation we have now is a disaster. So I give you an example. Last month, the Court of Cassation in France reversed in part a Court of Appeal decision setting aside an award of incompetence in the case Agarwal versus Uruguay. But the point is that both the Court of Appeal and the Cassation, they said when I look at the arbitration clause in the BIT, and it comes with procedural prerequisites, the usual, wait some time, go to the domestic courts, whatever. I'm not looking at issues of consent that goes to jurisdiction, but I'm looking at elements of that are prerequisite for the session of the tribunal, and therefore they go to admissibility, and therefore domestic courts do not have competence to set them aside. So this is wrong. It's simply wrong. But you know, if you're familiar with the topic, this is also common. How did that happen? And I'm very, very happy that Professor Tuvenen mentioned the Casinos Austria, because that is another puzzling read. So the majority of the tribunal came up with a made-up requirement that in order for limitations to the jurisdiction to be what they are, limitation to the jurisdictions and therefore conditions on consent, they have to be expressly talking about consent, which is not a rule of interpretation of any international treaty that we know, but they inserted that because they didn't want to dismiss the case on grounds that it would be a waste. It could be reintroduced, so they said, can we do something about it? And I'm also glad that you mentioned the opinion of Torres Bernardet, former registrar, because it circles back to a separate opinion of Couvreur instead, in the case of the award of 3 October 1899. And he makes the most sterling and crystal clear distinction between what is admissibility and what is jurisdiction. So if you read that decision, it says, well, that opinion, it says, what admissibility questions have in common is that, unlike question of jurisdiction, they are not linked to the establishment of some form of consent, but concern the appropriate exercise of the judicial function in light of the circumstances of a case. So again, consent versus anything else. We might discuss what falls under everything else, but let's just make sure we, you don't have to agree, but you understand why I think it's clear that everything consent goes to jurisdiction. Now, and maybe 3-4 minutes, why is that the case? Why so much confusion? There's 2 reasons and a half. I'll start from the half. This is not analytical, but it's a reality check, and it's true. It's true. You can do the research. This is all down to an article. It's not even an article. It's a chapter in a Liber Amicorum by Jan Paulsen that filled the gap and was a crutch for everybody that came afterwards. It's an elegant theory to distinguish between admissibility and jurisdiction, basically on whether the decision will be reviewable by domestic courts or annulment. I cannot do justice to that chapter to criticize it here. Let me just say, first, if you distinguish by the effects, you're not distinguished by the essence. So please tell me first what the distinction is, and then you tell me what the consequences are. But more importantly, that is a chapter, first of all, slightly provocative and heavily skewed towards commercial arbitration. You read it, the first 4 pages are about commercial arbitration. And maybe, and these are the 2 analytical reasons, it is true, perhaps, that in commercial arbitration, the importance of finality is such that that distinction is very much important to consider for domestic courts. And we also know that depending on the jurisdiction, and jurisdictional variations see through commercial arbitration, what is recevabilité in one jurisdiction is admissibility in another one. It's a different field. And that's why I say I'm happy to narrow down this analysis to treaty-based consent. And this fixation on reviewability that sort of flips the question in a sense is also not particularly convincing in and of itself, because there's no reason to believe that the decision of admissibility or inadmissibility should be more or less reviewable as such. I'm happy to take questions on those, but let's leave it at that. The reason why we have that much confusion, that much confusion that if we take, for instance, the Azanov Georgia Tribunals Award, this is a very learned one that pays, well, lip service or actual deference to the ICJ very much. And then it says, I have a scorecard of admissibility jurisdiction results that is this long on both sides, and I don't know what to make with it. And in this particular area, the authorities on which the parties have placed the greatest weight may provide the most efficient route. The authorities in this instance are Kilits and Ixkale, 2 cases against Turkmenistan that decided in different ways. And one is expressly described as relying on Paulson's article. So here's where we are. The sort of and why is it possible that maybe something that is relatively half-cooked became the standard? Because mostly it doesn't matter, and it goes back to you. Mostly it doesn't matter allows a sort of a lazy doctrine to become so ubiquitous that now it becomes difficult to sort of challenge it. Occasionally matters. I'm happy to discuss separately or later when it makes a difference. But this is where we are. We have the clearest enunciation of this doctrine in the ICJ case law and the most resistant confusion in the practice. A confusion that is self-immune. It's so confusing that most arbitration tribunals rather prefer not to address it than to solve it because it's just too wide that you take unnecessary risks when you try. So I know I'm preaching to the choir here, but maybe because there's Eric somewhere. And so the idea is in this field, I think there's unnecessary confusion, and the ICJ has described very precisely how to deal with the jurisdictional inadmissibility divide. I'll keep it there.
Well, thanks very much, Filippo. That's very satisfying. I feel, now that it's all explained, we're set, we can stop. But
you're welcome.
But in the interest of keeping this continually stimulating, I'm going to ask Kiran. I think you might have some comments on that. I know the casino case has come up a couple times now today, and I know that was a case where they actually addressed the Georgia-Russia case. Trying to distinguish it actually, which shows that little tension there that was built by that tribunal. But that aside, Kiran, why don't you jump in now and continue the discussion?
Sure, thank you very much. Really glad to be here with everybody, especially having contributed to WOW virtually for the last several years. To do it in person is really exciting. I'm going to start with a disclaimer, which is that my background is probably different from many others in this room in that I'm a commercial US litigator by training, and that is what I did for many years alongside my international law practice. So I can't help but let commercial concepts creep into my understandings of these topics. I like to think it helps make me very practical and better at applying things, but you will all, I'm sure, very much disagree. So I hope that I don't offend with my interpretations of some of these ideas. So following on from where you started, you've defined jurisdiction more easily than admissibility. I agree entirely with Filippo's definition of jurisdiction, which is it's basically the power of a court or tribunal, and in the case of ISDS, of a particular investment tribunal, to entertain a petition or a dispute in its entirety. Admissibility, in contrast, is whether it's the appropriate time, mechanism, or opportunity to do something. So from a US law concept, the easiest place where this arises is admissibility of evidence, right? We love evidence and document development and things like that. So the question is this particular document admissible? Is it admissible at this time? Is it admissible in its proceeding? So on and so forth. So it's a really concrete way of how do you shape the procedure, as opposed to jurisdiction, which is, well, what is the procedure and can it exist? Why is this important in public international law? I would come back to the UN Charter for that. And in Article 33, we have our peaceful means principles, right? That states through their sovereignty have the ability and and the self-sufficiency to resolve disputes or issues in any peaceful ways that they choose, right? So this is coming back to our modern international law concepts of, okay, well, we don't want gunboat diplomacy, we don't want wars, we're better than that, we will find peaceful means to do so. So now we come back to jurisdiction. So how do we choose to resolve those disputes, and where does that play into with particular disputes that may arise? Now, in terms of the ICJ, perhaps it's a little clearer, and we have some great cases that Anastasios walked us through on consent in that respect, including the fisheries case and also the Russia case, Georgia versus Russia. And in both of those cases, we have very clear examples of how does consent come into play to delimit the ICJ's jurisdiction over the matter. And so when we look at that, we get some guidance as to what I'll put back into my commercial concept. What is the mandate of that particular court? You know, there might be many disputes that arise, but the mandate is delimited by what the consent has provided. If you were to translate those principles over to investment law, I think they've arisen in a couple of very interesting ways, and we have less background to pull upon. So pulling on something that Ian mentioned earlier on, investment arbitration is a particularly young field. It's been a few years, but I did a study reviewing all the statistics by UNCTAD as to how many cases were publicly known and available, how many decisions were available. And so the last I looked, which I think was about a year ago, is that about 30% of ISDS decisions that are publicly known and available are pre-2010. And the remaining 70%, and I'm sure that number has shifted because I did this study the last time a year ago, and the time before had been a year prior to that, but it continues to shift upwards, obviously. 70% of them are from 2010 onwards. So we're in a very young area of law. It's only about 15 years, like barely a teenager, right? So, you know, the area of law can't even drive yet in most jurisdictions. So we're continuing to draw upon where there is greater richness. And in investment arbitrations, typically you have a treaty acting as your operative document, and that is where the consent lives. I always like to say that, you know, states are sovereign. They can do as they wish. They do not usually negotiate with or resolve disputes directly with private individuals or private companies. However, through investment treaties and the triangular mechanism through which they exist, they're open to ceding a piece of that sovereignty in exchange for foreign investment, attracting investors, creating guarantees, etc. But that operative document delimits that consent, and it also forms the mandate of the tribunal. So if the terms of that document are not triggered to allow a dispute to be heard by a particular tribunal, where we can't act because that tribunal's mandate is not perfectly formed. And so typically the way the principles of Georgia versus Russia, well, although it's quite a young case, I think it's 2013. So it's a 2013 case. It's not very old, but I did read in commentaries that although it is so young, it's actually been cited by investment treaty tribunals and in applications and advocacy by practitioners nearly as much as even Corso Factory. So although it's only, 2011. So even though it's quite young, it's been cited as much as some of the oldest cases that we typically draw upon, including Corso Factory. What's the reason for that? Well, what's really interesting about the way that Georgia versus Russia played out is that it was a question of whether what we'll call prerequisite. Again, my commercial terms are constantly creeping in, but you have the prerequisite for whether we can have jurisdiction, whether it's not or not it's been fulfilled. And here it was whether there had been negotiations between the parties. And what is the definition of negotiations is explored in quite detail in that decision. And it was premised on that fulfillment that you could proceed towards having the court hear the case. Similarly, in ISDS cases and also in the treaties, you often have different prerequisites or forks in the roads to be fulfilled before a case can be brought to an ISDS tribunal And that can include everything from cooling off periods to negotiations to exhaustion of local remedies. And then we heard a lot about the different ways that you may approach each of those terms from Anastasios, and you get a rich color and examples of that. But with over 3,000 investment treaties currently in force around the world, each of them interprets and applies what would be the terms to have a dispute heard by a tribunal differently. And obviously, we know that's all in flux these days. Many next generation treaties are putting more prerequisites into play. I've worked with many states who are continuing to work on their treaty development and renegotiation. And what I'm hearing from my clients is that they wish to preserve investor relationships. And if you end up in a dispute, you cannot preserve that relationship. So for those states that are still wishing to continue attracting investment, they don't want to end up in an ISDS case. Their objective is mediation. Investor state mediation is very attractive and increasingly being utilized and tested. Or they want to see local remedies, like local litigation, so that they can find ways to resolve it in a localized domestic context in line with domestic law, all in the name of preserving relationships with foreign investors whom they do not wish to see leaving, because typically that is what happens. When you have a huge ISDS case, it might lead to other similarly placed investors filing similar cases, and then you often do see a mass exodus of foreign investment. So that's certainly an element that's at play in the latest generation of treaties. And the local remedies element is also in play. And you're also seeing some states withdrawing from ICSID. You have other states coming back to ICSID, but you have some states withdrawing from ICSID. And part of that also relates back to the same principle that they wish to create other fora for resolution of disputes that are more localized or regional in nature. So that's a really interesting development that is defined by the types of principles that we do see in Georgia versus Russia. On the fisheries case, it's a similar issue, because here, as Anastasios explained in quite detail, the question was, well, what reservations are at play? And what are the definitions of the terms that are being used, so that they define the scope of the dispute, and then therefore define the scope of the mandate of the tribunal and whether there's an alignment between those different principles. A similar thing happens in investment treaties, because unless the claim has been perfected and the consent has been perfected such that a qualified investor has emerged, that qualified investor had made a qualified investment, that investment had been actually solidified and it was not only speculative or preparatory, that can end up defining whether the mandate aligns, the scope of the consent has been perfected and the mandate aligns with what's being pursued in front of the tribunal. So it's a really interesting opportunity to see these principles from ICJ and other public international law fora, principles that we've had since, the UN's foundation, playing out within different cases, and also into next generation treaty practice, which I think is the most interesting element of this, because we have a teenage ISDS is a teenager, and with this you see some evolution and maturity, and I think this is the next level of that maturity, where I think we're technically in the third generation of different investment treaties if you were to follow that phasing. So I'm quite optimistic for how we're shaping this area of law, but obviously we continue to draw upon the grandfather in the room, which would be ICJ area of jurisprudence.
Hopefully, ISDS doesn't have the same faith as a young priest Tutankhamun.
Maybe that's to you, Ian.
Well, thanks very much, Kiran. That was great. Moving down our case list, I think I'm going to turn to Diem right now. I think you can't have a discussion of jurisdiction and admissibility without talking a bit about mathematas. So we'll let you take that on and continue some of the discussion teed up by Anastasios.
Thank you, Ian. I'll focus on jurisdiction issue, the temporal jurisdiction that sort of is the common thread between mathematas and the recent judgment on preliminary objections in Azerbaijan versus Armenia. So investor state tribunals, as you know, are frequently called upon to ascertain their jurisdiction rationale temporis by reference to some critical dates. The date on which a bilateral investment treaty entered into force, at the moment the investment was made, the date of the alleged breach, and the date on which the dispute arose. And underpinning each of these temporal reference points is the principle of non-retroactivity. So, absent an express language of to the contrary, a BIT only binds a host state in respect of acts that occur after the entry into force of a treaty and a bilateral investment treaty. And this principle is reflected in Article 28 of the Vienna Convention on the Law of Treaty, as well as Article 13 of the ILC Articles on State Responsibility. And while conduct predating the entry into force of a BIT could be taken into account to illuminate or confirm the existence of a before the entry into force of a BIT. So the scope of a tribunal's temporal jurisdiction is further dependent on the wording of the treaty's dispute resolution clause. Some clause restricts the jurisdiction of a tribunal specifically to violations of the BIT, in which case the tribunal does not have jurisdiction over claims arising out of acts before the entry into force of the treaty. But there are certain dispute resolution clause that would permit jurisdiction over earlier disputes, or it may be altogether silent on the topic. And arbitral tribunals have often generally concluded that there's no jurisdiction over pre-PIT disputes. But when the Mavromatis judgment was rendered, there was not much jurisprudence on the issue of ISTS. And the PCIJ at the time was asked to determine whether the mandate for Palestine adopted by the League of Nations in 1923 and conferring jurisdiction upon the court over certain disputes between the United Kingdom and other League of Nations members would extend to dispute predating 1923. The court observed, and I quote, "The court is of the opinion that in case of doubt, jurisdiction based on an international agreement embraces all disputes referred to it after its establishment. In the present case, this interpretation appears to be indicated by the terms of Article 26 itself, where it is laid down that any dispute whatsoever which may arise shall be submitted to the court. The reservation made in many arbitration treaties regarding disputes arising out of events previous to the conclusion of the treaty seems to prove the necessity for an explicit limitation of jurisdiction." And this is the passage that Anastasios referred to earlier on. In a number of exit tribunals, in a number of exit cases, it has been argued that this passage gives rise to a so-called Mavromatis presumption, that according to which a BIT's dispute resolution clause presumptively encompasses any dispute submitted to the tribunal, including those founded upon facts predating the treaty, provided the claimant invokes a legal basis outside or external to the BIT. And I think that the reading is probably untenable for a number of reasons. First of all, the PCIJ ultimately held that the breach before the entry into force of the mandate, it continued after. So the quoted passage is not necessarily decisive to the outcome. And second, the very purpose of both the dispute resolution in the mandate and Protocol 12 of the Treaty of Lausanne, which established the substantive obligations standards for Ottoman era concessions, was to address disputes arising during the United Kingdom's occupation and administration of Palestine, which had already occurred prior to the entry into force of both the mandate and the protocol. And thirdly, the dispute resolution clause in Mavromatis, situation in the League of Nations mandate, was not attached to the substantive protections. It operated as a sort of standalone compromissory clause governing an entire class of interstate disputes, and a structure that is quite unlike that of a typical bilateral investment treaty. Investor state tribunals therefore have largely confined Mavromatis to its particular facts. So in Chevron versus Ecuador, for example, the tribunal treated the decision as sort of a historical curiosity and concluded that the BIT, including its jurisdictional provisions, cannot apply retroactively unless such an intention can be established in the BIT or otherwise. And reflecting a similar sort of line of authority, the tribunal in Kiran versus Belgium also remarked that even if one could discern a presumption of temporal jurisdiction in mavromatis, which is doubtful, the principle finds virtually no acceptance in modern interstate jurisprudence. So turning to then focusing on the same issue, temporal jurisdiction of a tribunal, the recent judgment in Azerbaijan versus Armenia, a case in which I had the privilege to be part of the legal team representing Armenia. As you heard from Anastasios, the court also made important findings with respect to its jurisdiction, rationae, and temporis. When we were formulating objection to the tribunal's to the court's temporal jurisdiction in respective events, or so for context, the CERD entered into force for Armenia in 1993, and it entered into force for Azerbaijan in 1996. So there's that period between 1993 and 1996 where there's certain claims that were raised by Azerbaijan, but the question remains as to whether it falls within this temporal scope of the court's jurisdiction. So we raised a preliminary objection that arguing that the court lacked jurisdiction over claims concerning acts that occurred in that period from 1993 to 1996. And in response, among other things, Azerbaijan argued that even if the critical date for the purpose of its claims were September 1996, acts that it complained of are of continuing or composite nature that began before but continue after that critical date, and therefore should fall within the court's jurisdiction. And the court ultimately accepted that there could be acts that continue or of composite nature that straddle the date, the critical date. But the court found that if it were to find eventually at the merit stage that a continuing or composite wrongful act commenced before but straddled beyond 1996, Armenia's responsibility would only be engaged for acts and omissions after that date. So the court will take into account facts before the critical date, but it only has jurisdiction for breaches that crystallize after the critical date. Although this may seem quite remote from investor-state arbitration, the work performed by the court is directly transposable. Investment treaties often restrict jurisdiction, rationae temporis by way of entry into force clauses, denial of benefits provisions, or limitation of acts that occurred prior to the treaty's entry into force. The tribunal therefore must decide whether a challenge measure could be instantaneous or continuing or composite. In the award in MCI Power Group versus Ecuador, certain similar findings have been made. The case dealt with contracts which were concluded and allegedly breached prior to the entry into force of the relevant BIT. The tribunal found claims relating to those contracts outside temporal jurisdiction, and that prior events may only be considered by the tribunal for purposes of understanding the background, the causes, or scope of violations of the BIT that occurred after its entry into force. So the court's reasoning in Azerbaijan and Armenia this further confirms the non-retroactivity of BITs and will supply arbitral tribunals, hopefully, with some authoritative guidance on how to pass a series of measures and locate the critical date in relation to their completion based on the language of the relevant BIT. Now, while mavromatis has been used several times and cited by several tribunals, Azerbaijan versus Armenia is quite new, and so it's going to be interesting to see how it's going to be used and cited by future arbitral tribunals in investment arbitration.
Well, thanks very much, Diem. I know in the recent case, the Azerbaijan-Armenia case, there was a dissent by Judge Taladi, and I was wondering if you probably are very familiar with that dissent. So what comments did you have on that?
I mean, I think it's kind of hard for me to comment, especially having acted as counsel. It's probably good for me not to make a particular comment on the.
Well, maybe put it this way: if you're in front of a class and you were trying to tell them what the distinguishing debate was between the dissent and the majority, how would you characterize it for the benefit of practitioners and students?
I have
totally descriptive. No commentary.
Perhaps you could do the honor for me, because I find it, maybe a little bit difficult to.
Okay, well, I won't pursue that then. So we have a couple of minutes left, and I wanted to return to the overall basically theme of the conference. We have a narrow piece on jurisdiction and admissibility, but as we've seen through our presentation by Anastasios and our commentators, there's been a lot of, we'll say, mixing it up. And if we look back even 10 years ago to the Palais lecture, there was a lament that there was a great enthusiasm by ISDS tribunals and lawyers and commentators and academics to bring in ICJ, PCIJ cases into that milieu, but it wasn't reciprocated. So we received a sense in our last conversation and through our keynote lecture that maybe that's changing a little bit. We're seeing a little bit more on the ICJ side, so maybe it's a little more reciprocal. But I was wondering, this is something that I think all of the panelists thinking about, that related issue. Is that likely to continue? Are we going to see more of ISDS being reflected in the ICJ, or is this kind of systematic issue kind of keeping the distance, so to speak, between the parties? In that, from an ISDS practitioner's point of view, we're always looking for bits and pieces to support our arguments because we're all litigators or arbitrators and whatever. We're looking for that kind of persuasive support, but from the ICJ side and from practitioners like Diem who are pleading, there's less of a need for that because obviously the court has its own jurisprudence. I don't know, Anastasios, what are your thinkings on this issue?
Yeah, from the back of my paper say that since the court cited the Court of Justice of the European Union in Firon versus Greece, I see no reason whatsoever for it not to cite investment arbitration case law where it applies directly in most of the cases, public international law. So I think that it is the matter of how the court, in the good sense, strategizes. If it is a time that the court feels that it should open up to the other factors and to other families, or I would say brothers or sisters out there, to more like nieces or like grandchildren or something like that, to other courts, even to other tribunals. I would say that yes, I think that I would say it is a good thing because I was one of those who was, let's say, startled when I saw the ICJ citing the Court of Justice of the European Union for various reasons, both normative and political. So I think that this is something that's heading towards the right direction.
Let's go down the table. Kiran, what are your thoughts?
So I'm probably least qualified on this panel to make any comment on this, but I'll just say that cross-pollination among different spheres of international law is increasing and certainly is desirable to avoid fragmentation of international law. And we've certainly seen in investment arbitrations that we have environmental issues, climate change issues, human rights, different kinds of topics to take into account. And I think the tribunals and ISDS are certainly grappling, as we've seen even from the way that they borrow case law and precedents, they're grappling with these issues. So I don't see why it can't go the other way. I think the question is more so about the legitimacy of ISDS decisions and whether they are prominent and authoritative enough for a body like the ICJ to feel comfortable relying upon. So I think I think if that legitimacy crisis can be resolved in a positive way, then we will see more of the ICJ borrowing. Because I think there is certainly an interest in growing in the way that Anastasios described, right? They are looking for inspiration the same way that we as ISDS practitioners are looking for inspiration, but I don't think we're there yet. I will certainly say that. Maybe another 10 years. Let us grow up a little bit.
What do you think, Diem?
Well, I think definitely a question I hopefully can comment on. I do think that, I fully agree with Kiran and Anastasios in the sense that I think, to avoid fragmentation of international law, and it's not like the ICJ has, extensive jurisprudence, but it doesn't cover all sorts of legal issues. So there might be inspiration from ISDS tribunals. The judgment that came out yesterday by the court in the Gabon Equatorial Guinea case, I think for the first time cited to an interstate arbitral award in the South China Sea arbitration. So that is something that's very interesting to see, that, the ICJ is actually citing to other bodies when it comes to, so, there's no exclusion to ISDS tribunals for sure.
Well, and I guess we'll give the final word to Filippo.
Thanks.
What are your thoughts?
Very short, I think. So I'm glad Firom came up. So Firom and Georgia, Russia, but also Diallo were decided when I was working for a year at the court. So I remember those cases. And I know mostly we remember Diallo for clarifying that the treaty-based law is different from custom law on the protection of aliens. But from the inside, it was a big deal that the court decided to cite human rights instruments, the European Convention and the African Convention. So there was a case of cross-pollination, whatever you want to call it. And then Firom, I have to say, there hasn't been a lot of that since, and we're talking about 15 years ago. I do believe that mechanically it's easier for the tribunals to wait for the court's decision, especially on matter of secondary norms, on interpretation, on responsibility, on procedure, on quantum. I'd be very interested to hear today. Whereas the other way around is trickier. So what kind of teaching could come the other way around, especially from a system that is not a system? So why would the ICJ would rely on something that might be controversial, but also was produced to resolve a dispute and not to set, a rule of law? So I think what would happen very easily, and it's very common, so it's not a revelation, is that awards will be read and studied and maybe used even when they're not cited.
I agree with that.
Well, I think that's a great place to stop our first panel for the day. I just want to thank our presenter, Anastasios. Thank you so much. And our commentator, the Kiran, Diem, and Filippo, for their excellent analysis. And I believe we're going to take a break till panel 2, till what time?
Yes.
1:30.
1:30.
1:30.
We're having lunch.
So folks we'll have lunch here for those who are in person, and that those who are watching virtually, we'll see you back for panel 2. And so thank you very much.